Is this visible?
Yes, please. Visible.
Yeah.
Yes, sir.
Thank you very much. Well, it's nice to be here among so many colleagues. So it's very important session in terms of because the ICSIIP is organizing perspective on IBC. It's a series of 5 sessions. It's a virtual workshop. And today we are starting with this session on voting and decision making in the committee of creditors. So basically, uh, I'm presuming that most of the participants here are IPs and who are all familiar with the working of the CIRP. They must have done some liquidations also, and they are familiar with CoC. So they must have constituted CoCs, um, worked with CoCs, and so much of experience is there. So basically, you might be wondering what is that need to discuss in this topic. Most of the things are very familiar. I was also thinking that when I go into the details of the thing, I see that there are small nuances which sometimes we miss, and then it is always better to have some revision of these things, and then once in a while we'll know. And when some issue comes up, we know that this is going to be very helpful. So, and I request all the participants who are aware of this topic and who can participate, if any, they can share their opinion or experience or anything like that. It will be very helpful to me, and I will be very thankful to. So now, basically, what I propose to do is that I will start about discussing about the concept of CoC and how the importance of CoC and all that for the initial stage, and then go into the other guidelines and regulations on how to constitute a CoC, how to conduct a meeting, and all these things in the later part. So that is what I'm proposing to do. So now this let us I would like to first as a background to discuss these three pillars under CoC under IBC 2016. So commonly it is said that the RP, the committee of creditors, the CoC, and the adjudicating authority are the three main pillars of the CIRP process, and of course and the entire IBC process basically. So we know the roles of all these people. RP does the main driving of the CIRP. He does it, and then we have to see how he gets appointed. He gets the claims. He gets the other people, and he manages the company, takes over assets of the corporate debtor. He sees and what are the things available, and he tries to, if it's a going concern, he tries to manage the company and try to maintain the value of the corporate debtor. These are all the very important roles which the RP plays. And then COD. COC is COC like is said to be like a board in a company, and RP is said to be the CEO of the company. So they have to work in tandem. And the COC has to decide on so many things, whatever RP can do, but RP has to consult COC and get approval of COC in at every stage. So COC is the main decision-making body. And these two are the third pillar is the adjudicating authority, who gives a stamp of authority on all those things. So once adjudicating authority approves something, then it becomes final, and then it applies to all the shareholders, all the stakeholders, shareholders, employees, workmen, even government departments. Everybody has to be bound by the decision. So these are all the basic concept of the IBC, which has been conceived in 2016. So now we have about 8 years experience of IBC, and then we have our own impressions of how COC has to function, how it is functioning, And we also know how adjudicating authority, what is the experience, and so many other things we are very familiar with. But before we go into further, what I would like to know, what I would like to see is that what is the situation prevailing before IBC? Because if if IBC's importance is to be understood, then we have to be very clear about what was not there when IBC was not there. So most of us may be familiar with this. Before IBC, this SICA was there, Sikh Industrial Companies Act, and then there was the DRTs under which all this recovery was happening, and then there was a SARFAESI Act where bankers can attach a property and recover without the involvement of the courts. And then we had the Companies Act also, 2013, earlier 1956, where there was provisions for liquidation of winding up of the company. So we had several statutes, several forums like BIFR, Company Law Board, DRT, District Court, High Court. So all these things were there. So what is used to happen is that so it is so fragmented, and then our recovery percentage was so low, and then the main beneficiaries, if you see, of the earlier system was the people who borrowed. So they used to have a good time, and there were a lot of people who who started a company, and if they're not able to run it, then it is the responsibility of the banks. If they are able to run it well, then they make good profits out of it. So that was the scene. And then banks, so if you trace the history, in 1991 there were reforms and all that. Then over a period, the banks also grew, and then there was a lot of credit flow into the system, but the recovery remained very poor. And the banks, and by the time 2021 to 2010 or something like that, like a lot of banks started losing money, about almost 10% of NPAs and all that. And all this situation became very, so by the time the 2015, it was very clear that something drastic has to happen. Otherwise, the system cannot support. So in that scenario, then this IBC was enacted. So the basic concept, which the conflict which was being faced, is that equity versus debt. See, in a company, the contract is between equity and debt, and so promoter puts in some equity and almost borrows about 3 times, 4 times of the equity as debt. And then the concept is that as long as the debt obligations are met, equity owners have complete control. As long as debt obligations are met, equity owners have complete control and creditors have no say in how the business is run. When the default takes place, control is supposed to transfer to the creditors. Equity owners will have no stay at that point of time. This is what BLRC report says. They have basically tried to analyze the concept of how the system operates, the economy operates. And this is basically the interplay between equity and debt. So, so how this is going to make relevance to us? Because when when there is an insolvency and how it is to be resolved, because it has to be resolved, otherwise it will be like lost to the overall economy. And of course, a lot of people, the workers will lose, and then a lot of taxes will be lost and all that. So insolvency resolution has two approaches the world over. One is creditors manage the corporate debtor and the resolution process. Second is the debtor continues to manage the corporate debtor during the resolution process. And India has adopted the creditor in possession resolution model. So there are economies like US has a system where debtor keeps control of the company even when there is suppose if what is called Chapter 11 bankruptcy and all that, they go for it. The debtor who to himself declares that, and he goes to the court and says that I want to reconstitute my company and all that. So the creditors have a supporting role, but they don't take charge of the management of the company. Whereas in creditor-led model, it is the creditors who do it. So in this model, our BLRC report has said that we will adopt this creditor in possession, creditor in control model, because the previous experience prior to IBC has been that it is very like the debtors have been taking advantage of all these things, and then they said we'll go for a creditor model. So what happens is that when creditor-led model, creditors have to take control of the company, and they have to run and they have to try to resolve the insolvency. But the question that comes is, among creditors, who will run the company and who will do the resolution process? Because there are varieties of creditors. There could be operational creditors, there could be government departments, there could be other financial creditors, secured creditors, unsecured. So all these people have different interests and different capabilities, and how these people have to be seen. That is the question. So what BLRC says in this regard, I will just quote. When a firm defaults, the question arises about what is to be done. There could be many approaches. One could be that you restructure some debt and go for some interest reduction and then elongation of the repayment schedule and things like that. And so do some debt restructuring. That is one way of doing it. Another way of doing it is straight away go for recovery of the assets and then go for liquidation. So there are different ways of doing it. Another way is to sell it as a going concern and see what is to be done. So, who will decide which approach is to be taken? That is the question. So, many hybrid structures are also possible. And the committee believes that there is only one correct forum for evaluating such possibilities and making a decision, a creditors committee where all financial creditors have votes in proportion to the magnitude of debt that they hold. So, what VLRC said is that it is the creditors committee which can decide whether a company has to go into liquidation or whether it has to be restructured and giving another life has to be given to the company. So that is what BLRC decided. Their firm recommendation was that a creditors committee has to run the show. So in this background, the act provided that there will be a committee of creditors, which we are going to discuss more about that. So now just briefly, what are the major responsibilities of CoC under IBC? What they are supposed to do? They have to, once the IRP is appointed by the what you call adjudicating authority, they have to decide first whether IRP is to be continued or another resolution professional is to be appointed. And then they have to supervise the CIRP process. CIRP process, there are various stages are there. We have to finalize the claims and then we have to finalize the assets of the company to decide what are the assets and attract get some resolution plans and all these stages. We have to see how CoC will be. So for all these stages, authority to approve various actions is the CoC. Then the rejection plans, the resolution plans can be approved or rejected by the CoC only. And they also decide whether a company has to go to liquidation or it has to be supported. So these are the prime responsibilities of CoC. But how CoC has to approach these responsibilities? It seems to be a very academic question, but then there is a lot of debate has taken place on all these things and how CoC approach. Any opinions on this? How CoC has to function to make a CIRP a success? Anybody can share their opinion. Well, so so when these questions came up within IBBI and within the MCA and all government departments and all that, what they thought was CoC has to have some code of conduct. So, but code of conduct, getting a code of conduct for CoC, IBBA was hesitant to do for the simple reason that CoC members, they don't report to IBBA. They are regulated by other regulators like RBI and sometimes SEBI, if it is an NBFC or something like that. So, what guidelines can IBBI can give to CoC? That was the issue. Then this went on for some time, and then ultimately everybody said that because CoC is not living up to the expectations of the expectations of the IBC. That was somebody's people's opinion basically, because there were delays happening, and then there were proper decisions were not being taken, and CoC members were not taking interest, and then it was becoming a routine affair like another meeting. So then they decided that then there was another decision of High Court of Delhi also, that their code of conduct has to be devised for CoC. So IOB, this IBBI went and they find ultimately they gave a guideline system of the set of guidelines were issued in August 2024. So these guidelines were basically the precursor to these guidelines. We can say is that what I found an article of Dr. M.S. Sahu, where he was talking about what are the duties of CoC, and then his uh, thought process has been then CoC Dharma. CoC Dharma he mentioned, and what he says is maximization with fairness. That is the call he has given. So maximization, of course, we are all familiar with the objectives of IBC, where maximization of the value of the assets is one of the basic objectives of IBC. So what he said in his article was, when a firm fails to service a debt, okay, there are different approaches. If recovery is pursued, the value of the firm, if recovery is pursued, the value of the firm is destroyed. What it means is that suppose we know in the surface the bank attaches the assets of a company if it is overdue or something like that, and then they sell the assets. Then what happens is that the firm is destroyed. The firm cannot continue the business because most of the important assets will be charged to the bank and it will be sold. Then if it goes to liquidation, liquidation destroys the going concern plus surplus and renders its resources idle till reallocation, reducing the value of the assets of the firm. So liquidation value of the assets are reduced, and even for the creditors, it is not possible to what do you call get the good value. So if it is a going concern, it will always have a surplus over the liquidation value of the assets. So third approach is resolution. Resolution preserves the going concern surplus, which what it means is excess of fair value over the liquidation value. So while liquidation destroys the going concern surplus, resolution preserves the going concern surplus. Therefore, CSC must COC must prefer resolution wherever fair value exceeds liquidation value. This is what the crux of the article of Dr. Sahu, which I thought will be useful to understand the concept of how the CoC has to function. So then I was talking to you about the guidelines. And before going to the guidelines, let me just discuss this commercial wisdom also. See, apart from the fact that CoC has been given powers to decide on what is to be done, the courts have said that the commercial wisdom of CoC is non-negotiable, not non-justiciable. It cannot be questioned in a court of law. This is a very important concept because, see, even if CoC comes up with a good plan and approves a plan, and somebody is going to question that, and it is going into the court and appeal and and all those things, then it is not going to serve the purpose. For this reason, commercial wisdom has been held as supreme. And yeah, I mean, you might have noticed that there is no definition of commercial wisdom in IBC. It evolved over a period of time. The case which I'm quoting is the Supreme Court has said in the matter of CoC of SR Steel versus Satish Kumar Gupta and others. So there it says that CoC must decide on whether to rehabilitate a corporate debtor or by accepting or rejecting a resolution plan. Just a second. So there it is clearly laid down by Supreme Court saying that CoC has to assess the viability of a resolution plan and negotiate with the potential resolution applicant for the best deal. They should get the best possible deal, not only for the CoC members but also for others. So that also they have to see that the company gets sufficient working capital and tries to re-establish itself. But then in that case, what is the role of adjudicating authority? The adjudicating authority's jurisdiction is circumscribed by Section 30, subsection 2. What it says is that under no circumstances the AAA can trespass upon the business decision of the majority of the CoC. As regards the appellate authority, their review is laid down in Section 32. So both adjudicating authority and appellate authority, they have to function within the Section 30, which means that they cannot question the business decision of the CoC. They can only see, they can have judicial powers to review whether all the parameters under Section 30, subsection 2 have been complied with. All the processes which are stipulated have been mentioned. All these things have to be seen. And as long as those parameters are complied with, the business decision per se cannot be questioned. This is the concept of commercial wisdom. So this commercial wisdom, there's going to be another session, I think tomorrow, on commercial wisdom. So I'll not discuss much about commercial wisdom. There are different cases and different, what are the limits of commercial wisdom, and there are so many other things that I'll confine myself to other parts here. So there is one more case which is a very important case. SC has observed in the matter of K. Shashidhar versus Indian Overseas Bank. The adjudicating authority is required to satisfy itself that the resolution plan as approved by CoC meets the requirements specified in Section 32, which I just said. No more and no less. That is what Supreme Court has said. So, judicial responsibility is to see that the process or all the parameters are complied with. They cannot question the commercial wisdom. So this is the basic concept. So CoC has to take major decisions and they have the authority to take it. And whatever the authority they exercise, that cannot be questioned. As far as business matters are concerned, they cannot be questioned by the adjudicating authority. So now, before going further about the functioning of CoC, I'll discuss something about the guidelines which issued by the IBBI, which are recent, and maybe it is useful for us to know this. So IBBI guidelines for CoCs were issued on 6th August 2024. These are self-regulating guidelines issued to financial creditors who are largely under supervision of other regulators. So IBBI thought that it cannot directly tell something, you cannot order CoC members. They have passed some self-regulating guidelines. So objectivity and integrity, this is the first thing which they are emphasizing. They follow the code and regulations and maintain objectivity and integrity in the CoC's decision-making process. Objectivity, it means that they have to take care of not only their interest as financial creditors, they have to take care of operational creditors, and they have to see that the going concern gets protected, or they have to see that the operations can start with some change of management or a new person, new management coming in and all that. So this is the objectivity they have to maintain. And then second thing is, a member shall share with CoC and IP any relevant information available with him and foster informed decision making. So for decision making, what happens is most of the times RP is not able to get the information. They most of the times we face the problem that the management is not sharing the accounts. They don't have the information. They are not sharing the office is closed, or all these difficulties are there. But most of the times, what happens is that the banks or the financial creditors, which have been dealing with the corporate debtor, they have a lot of information with them. They have a lot of previous stock statements could be there. It could be audit reports could be there. Some forensic audit would have been considered. So all these things should be shared with the other members of um, CoC. Then another aspect which is emphasized is independence and impartiality. A member shall disclose any conflict of interest with corporate debtor. This is, of course, important in all aspects of public functioning. And then, if suppose COC member, as any member and a particular manager has sanctioned a loan, or he has dealt with the particular corporate debtor, it is best to inform the COC in advance, so that the charges of conflict of interest will not come at a later date. And then you have professional competence and participation. So members should keep themselves updated with the provisions of code and participate actively, constructively, and effectively in deliberations and decision making of the CoC. So this is a very important thing, which means that most of the time we find that CoC members have to be told what are the IBC guidelines and how something can be done, how something cannot be done. And many of these CoC members, especially banks, are influenced by DRT guidelines and surface guidelines. They say that why we cannot do this, why we cannot do. And most of the times we find that suppose RP proposes that let us go for a forensic audit or a transaction audit. They feel that what is the need for that? Why we should spend money on that? Whereas it is the duty of the RP to file an application for COFA transactions. He has to examine these things are there, and within a time frame he has to file. Whereas for that you require the forensic audit, and you require the transaction audit and other verifications. But if money, and you may have to engage an advocate and all these things. But these are all the difficulties which RPs have been facing with regard to CoC function. What IBPA says that CoC has to be very much aware of these guidelines, and then they have to cooperate and provision, and they have to participate actively, constructively, and effectively in deliberations and decision making of the CoC. So these are which are the things which are being emphasized by IBBA. Then another aspect is cooperation, supervision, and timeliness. IBBA says CoC members have to supervise and facilitate the IP in discharging its duties under the code, facilitate expeditious appointment of various professionals within the timelines prescribed under the code and regulations. So again, the emphasis is on what CoC has to do so that IP does its duty in timely manner and very clearly and very effectively. And then endeavor to resolve any interstate dispute between the members, particularly in relation to claims, preferably through dialogue or non-adversarial means, and avoid litigation. So this has sometimes happened in the CoC because some member there is a conflicting claims are there, and one member says that I have a pari passu charge, one says I have a prior charge, and other people question that, and whether NOC is there for a sharing of charge, or all these are some of the issues which come up. And then sometimes mortgage, whether mortgage has been done to one institution, it has not been done to another. So all these questions come. If such questions come up, what IBBA says that you please settle such disputes among yourselves and don't make big issue out of these things. So basically, it is for non-adversarial settlement, and you should avoid litigation. And another aspect which is confidentiality. Confidentiality is with special reference to the undertaking. Where all of the CoC members, we take a confidentiality undertaking, and they are supposed to respect that undertaking. They should not share the details of the corporate, especially any strategic information, marketing information, or the value of the particular asset or value of the company. All these things have to be kept confidential, and this is emphasized by the IDVA guidelines. Then costs. The costs have to be again. CoC is the institution which decides what are the costs, and they have to make sure that the costs are reasonable. They have to decide on the expenses of IB expeditiously, fix the fee of liquidator prudently. So all these things are supposed to be. Most of the people are very cost conscious in CoC. That is, of course, our experience. But then it is also emphasized that, especially sometimes what happens is large amounts are shared for advisory fee and for advocates fee. Lot huge amounts are spent on advocates fee and all that. Such things have to be kept in control. There's they have to attend the meetings regularly. They have to um, they have to diligently recommend for the inclusion of the belated claims. So this is specifically IBBA is saying this uh, for the reason that when there is a claim, our IP in the not in the first meeting, but over a period, he mentions what are the additional claims which are coming in and how they are to be settled, how they are to be admitted, and all that. So there should not be any delay or any obstruction to such things because this is the process, CIRP process, and COC members have to respect that. Because this, there could be some chance that somebody's voting share will come down if a new claim comes in. But then such things, that is why specifically I think it is mentioned here that such things should be decided fast. And then general things like that, you should generally participate in the meeting and then ensure conduct of the meeting at regular intervals. All these things are mentioned. So, so IBBI has taken efforts to issue these guidelines, and they want to make sure that COC members are do participate in the COC meetings in a professional way. They are well aware of the guidelines. They take interest, and then whenever there is assessment that has to happen, the resolution plan comes. They have to make an assessment whether this is enforceable, this is implementable, viable. All these things are there, and so they have to. All these responsibilities are highlighted here. So now we are covering about the guidelines and all that. So I would like to touch upon some other things. This is what I just shared, sharing of information. Feasibility and viability of the corporate debtor has to be studied, and COC members have a huge responsibility in this. They have to make sure that that responsibility is um, uh, very enforced very clearly and without any subjective interventions. So now we'll talk about the constitution of the CoC. Who does the constitution of the CoC? The IRP's first duty is constitution of the CoC. Within 30 days, normally he has to do it. Once the we know the timelines specified. Most of the times we are very familiar with the timelines. Within once the order is issued, appointment of IRP takes place. Within the 3 days, public announcement has to be made and claims are to be collected. And some 14 days time is permitted for claims. And then after 14 days, 7 days time is permitted for collation of the claims and getting clarity and admission of the claims and all that. So 21 days. And after that, they have to um, see whether any AR is to be appointed. And then they have to file an application. IRP has to file an application with the adjudicating authority for what you call constitution of the COC. That is roughly about 23 days. And once the constitution application is filed, within 7 days, the COC has to meet. These are the general guidelines, which of course are going forward. I'll discuss the timelines also. So this is now some questions which come up in this is CoC shall comprise of financial creditors of the corporate debtor. Related parties among financial creditors shall not have any right of representation, participation, or voting in the meeting of the CoC. So financial creditors, yes, but related parties among financial creditors are not agreed, are not permitted to be members of the CoC. And then we all know that CoC members' voting share would be proportional to the members' share in the total financial debt of the corporate debt. It is financial debt, and whatever percentage of financial debt they have, their vote share is decided on based on that. Then suppose there is a person, there is a creditor, suppose where any person is a financial creditor as well as an operational creditor. The person will be financial creditor to the extent of financial debt, and he'll be an operational creditor to the extent of the operational debt. So just because there are both types, you cannot club and say that I'll have a higher financial share. Voting share cannot be there. And another aspect is where an operational creditor assigned or legally transferred any operational debt to a financial creditor, the assignee or transferee shall be considered an operational creditor. So assignee could be a finance company, NBFC or anything, but just because that they cannot claim to be a financial creditor. They have to be treated as an operational creditor. You might remember the case of SR, where SR Steel, where Standard Chartered Bank was treated as an operational creditor. They had a huge dues of more than about 600 crores were there, but they were treated as an operational creditor. And then because they were treated as an operational creditor, a lot of issues came up, and then a lot of litigation happened in both the NCLAT and Supreme Court. So, and one more aspect which I would like to touch upon here is that home buyers. Home buyers in a real estate, they are they are also financial creditors. Because in earlier definition of financial debt, home buyers were not specifically covered. Though there was a item that any other financial debt was there in the definition. So, but it was decided in a court case, that is in Pioneer Urban Land and Infrastructure versus Union of India. In this case, the Supreme Court confirmed that the home buyers advances, the amount paid by home buyers will fall into this category, and then they have to be treated as financial creditors. This is the decision of the Supreme Court, and because of that, and ultimate later and subsequently, some amendments were also made into the IBC, and allottees were of the real estate projects were treated as financial creditors. So now, then once this was decided, there was a question of how this home buyers will be represented in CoC, because there could be hundreds or thousands of them, and all cannot participate in a what do you call CoC meeting. Then it will be uncontrollable. So then it was decided in the IBC that there be an authorized representative who would be representing that the authorized. Then there are mechanisms which we have been decided how to ARS to be selected and all that. We'll come to that in a short while. So there is a lot of discussion in IBC and regulations also, like what is the functioning of AR and how AR has to function, and what is the duties, what is the responsibilities, and what are the powers and all that. But one thing which I would like to emphasize here is that AR means it does not just mean that AR who is representing home buyers. There could be other authorized representatives because as per Act, there are other people who can have a authorized representative. Here I'm just giving a chart which you can see. See, there could be different ARs. Suppose there is a consortium or a syndicated facility. Normally, in such facilities, there already a trustee or agent is appointed by the consortium or syndicated for taking care of the documentation and all that. So that trustee, if their documentation permits, he can continue as a authorized representative of the consortium. So this set of financial creditors who come under the consortium, they can engage the trustee to operate as AR. Also, they also have the freedom that they can directly participate in the COC meetings. So what does this AR do? Same thing. He attends the COC meetings, but he has to take preliminary views prior to COC meeting, and then all ARs have to do this, sir. And then they have to seek voting instructions from FCs, and they have to vote as per their vote share in the concerned FCs, and they shall not act against the interests of the FCs, and they shall abstain from voting if instructions are not received. These are very bullet points I have mentioned what AR can do or cannot do. But what happens is they have to get directions from the respective financial creditors and do the voting. Then there are other second type of ARs who are working for um, debenture holders or fixed deposit holders. Even in such a debentures issue also, debenture trustee is appointed, and then that trustee represents the debenture holders in most of the meetings and all that. We have seen in big cases also, the debenture trustees act as the ARs. Similar, say they also have the same responsibilities, and they have to take the views of their debenture holders and vote according to that. And there is another provision in the IBC where suppose a financial debt is given and that person is not living, the administrator as executor or guardian of such thing, such a loan, they also can work as an AR, administrator or guardian can work as an authorized representative. I'm just changing this. So this is a third type of AR. And then fourth type, which most of us are familiar, is that when there is a class of creditors. Class of creditors, typically home buyers. So there, what happens is that there is no already decided representative for such people. So they come together and form an association, or they come as a group and file a case and all that. So in such cases, it is the responsibility of the IRP. As soon as he comes to know that there are several claims of such people who can be grouped into a class of creditors. Once he notices that such class of creditors, then he has to appoint an AR for that purpose. So how that AR is appointed? See, at the time of claims, admission of claims and all that, what they do is, if IRP has to give a choice of names of 3 IPs to the home buyers who have submitted the claim. They say that these are the people who can be representative, and then they give, and then they vote and they select a person, one of the IPs, to act as an AR, and that becomes the AR. So now he'll be AR. Initially, he'll be an interim AR. Now, because there is some change in guidelines which has come recently, once the AR is approved by the home buyers, the IRP has to file an application in this NCLT for approval of this AR. The adjudicating authority's approval is required before somebody can function as AR. Prior to that, he can continue to attend the meetings and do all what is required as an interim representative. So this is the thing. So once that happens, then AR is appointed. So what AR does is, AR for a class of creditors shall attend all the meetings in CoC either in person or through video conferencing or other video audio visual means. So he can attend the meetings. During the period of application of appoint of year, I said interim person will be there. And then seeking preliminary views. This is again an important thing. Sometimes it becomes very crucial, um, because see what happens is when a COC meeting is there, when agenda is circulated, there are certain things which the AR cannot know whether home buyers will support or not. What is the view of home buyers which they have to collect. So for that, this seeking of preliminary views is there. So he should circulate the agenda to the creditors in a class and then seek their preliminary views on any item of agenda to enable him to effectively participate in the meeting. So once the notice comes, then he has to send the notice to all the people and then ask them to tell what he has to do. Then he has to collect the opinions and then maybe collate the thing and decide. And then he has to represent all this class of creditors in this COC meeting that my people are saying this is what has to be done, or this cannot be done. We don't agree with this, or we don't like to do this, and all kinds of things. How this is to be done is also stipulated. For getting the preliminary views, a window has to be open 24 hours after seeking the views. That is, agenda has to be circulated, and then he should ask the RP to open a window for voting, or this is not exactly voting, this is just for giving opinions. Maybe what we have done, at least what I have done in some cases, is that I have circulated a Google form, giving the agenda and then saying that what are the different possibilities, they agree, don't agree, or any other view, or three, four views we have separated. We have mentioned that whether you agree with this or not. So Google form I had done, I had represented some 800 home buyers in one case. And then there we used to send Google forms and ask them, and then you get a Google form in a Excel table, it will come who says what and all that, depending on what the opinions are, who is to tell preliminary views. That way, Google form is a very, you can do it without any expenditure. That is one way of doing it. But at least you should give them 24 hours time. It has to be, and then once you send a notice, you wait for 24 hours, then ask them to give their notice, and that window has to be kept open for at least 12 hours. So they should give time. The home buyers should have time, at least 12 hours, to tell what they want or they don't want. And then after that, you should compile all the opinions. And then this is the reason why wherever AR is present in a COC meeting, a longer time frame is required for notice. So notice cannot be just you give a notice and tomorrow morning you can have a meeting. That is not possible when AR is there, because AR has the responsibility to collect the opinions, the views, and then for that also he has to give time about 12 hours, and then he has to wait for 24 hours and then wait 12 hours window and then get the opinions. So this is the way the AR has to function. So now, after that, one more thing which is special as far as voting is concerned, that will come to um, uh, sometime later when we do voting part. So now, we'll know more about the constitution of a COC. So I am giving a small example here just to get an idea. This is corporate debtor is SPV Steels Limited in this example. And then we have to finalize who are the members. You are able to see the table.
Yes, sir.
Yes, sir.
Yes, sir.
So I've of course imagined a scenario and then given different types of people. Uh, Name of the first claimant is ABC Bank, and they are given working capital facilities, and they have claim is for 8.5 crores, admitted claim, we can say. And then we have BCD Trust, who are trustees for debenture holders. So they have apparently company has taken some debentures also, and then they have borrowed. These are all secured debentures. And then there is a representative. There is a trustee for all these uh, debenture holders. So they have a claim of 35 crores. And then you have RP Traders, who is a related party, who is a supplier, who has supplies coal supplies. And then he has also given a loan to the company. He has given a loan of 3 crores and he has made a supplies of 3 crores which are not been paid. So he has made a claim. Yes. And then there's a GST department whose claim is for 1.9 crores. IT department 3.4 crores. Employees 2.1 crores. Employees have the salaries and terminal dues. Workers 1.98 crores. And there's a KK Finance company which is given a term loan, which is kind of we can say that regular purpose, corporate purposes. You can say they are given 6 crores. So total comes to 64.88 crores. So now, may I ask you people to maybe take 2-3 minutes and finalize who will be the COC members? I'll um, so ABC Bank will be a member of COC because they have given working capital. It's a financial credit, financial debt. So any doubts on that? Yeah. So ABC Bank will be a member of is a financial creditor, and then he'll so their claim is for 8.5 crores. And then next we have this secured debentures. Um, BCD Trust is a trustee for debenture holders. There could be any number of. I'm not specifically mentioned how many debenture holders are there. Maybe we can assume that maybe there'll be 500 debenture holders, or maybe 1,000 also. Um, so together, 35 crores have to be paid. So whether there'll be a financial debtor, financial creditor, and then there'll be a member of the COC. Any opinions on that? Okay. So secured debentures, they are financial creditors. There are also some security is there. Maybe it is whatever security, probably it is working capital, it is current assets, or some specific fixed assets have been mortgaged them. So they are secured creditors, they have as financial creditors, they'll be into the uh, COC. Then next you have RP traders who are suppliers of coal. They are given 3 crores. Whether they'll be a member of the COC, anybody? They are coal suppliers. basically, so they are not financial credits. They are basically operational creditors. So for that reason, they will not be members of the CoC. And I find only there is one operational creditor with a claim of 3 crores. So that out of a total 65 crores, their claim is 3 crores, which means that which is less than 10%. If it is, the guideline says that if it is more than 10%, suppose he has supplied material to the extent of 6.5 crores or maybe 7 crores, and his claim is admitted for 7 crores, suppose. So then his claim will be more than 10% of the total admitted claims. In that case, he can be a member of the CoC as an observer, not as he does not have voting rights. But here he has only 3 crores, and so he will not be a member of the arbitrators. Will not be a member of the what you call CoC. Then arbitrators have also given a loan of 3 crores. So on this basis, they can be a member of the CoC, but since they are a related party to the promoters, they cannot be admitted into the CoC. Then, of course, GST department, they are considered operational creditors, and we don't have any information whether they're secured or unsecured. Even if they are secured, they are all operational creditors, so will not be a member of the CoC. IT department similarly will not be a member of the CoC because IT department dues come under the operational dues. Then we have employees and then workers. They have a higher what do you call status while settlement of dues and all under sections 53. But then here they will not be members of the CoC. And similarly, workers also, employees and workers, they cannot be members of the CoC. But then we have KK Finance, which is a finance company, and they have given a loan of 6 crores. And then they are not noted as a related party. So there is a financial creditor, and then they have given 6 crores. They will be a member of the CoC. So now we have 3 members of the CoC. One is ABC Banks with 8.5 crores, debentures holders with represented by a debenture trustee, 35 crores, and then KK Finance, which has 6 crores. So totally, they'll have 35, 43, 49. So financial debt comprises about 49 crores, and then there will be 3 CoC members. This is just to get an idea. It's a very simple exercise which I had made. Any questions on this? If you feel, you can raise. Suppose now, just to examine it further, suppose RP Traders is not a related party. They have given a loan of 3 crores, which is a loan, which is financial debt. So will RP Traders be a member of the CoC if it is not a related party? Somebody can answer?
No, because they'll be operational creditors.
Pardon me, sir?
It looks like they're called suppliers, so the operational creditors so won't be part of the CoC.
No, but apart from coal supply, they have also given a loan.
Okay, if they're given a loan, then yes.
Because if you see item 4,
Yeah.
arbitrators related parties coal supplier. And
Oh, yeah, it is
arbitrated-
written, is it? Oh, I say coal supplier, only that part. Okay.
Yeah. So fourth one is they are also given a loan.
Yeah, yeah.
So
To that extent,
So
Only
now
for
they'll
to that
be,
action.
yeah,
Yes, sir.
correct. To that extent, they'll be a member of the CoC because um, their financial debt is to the extent of 3 crores, which has been admitted. And to that extent, they'll have a voting share and they can participate in the CoC. Now, suppose another question, the coal supply we're talking about, which RP traders, suppose the RP traders has discounted this supply. There's a bill of exchange, they have got it discounted from a financier. We can assume that KK Finance themselves have discounted the bill. Okay. So in that case, and of course, discounting has happened. The CD has not paid the finance company on the due date. So that has become what you call defaulted for that. That bill has not been paid. So this being the case, so now coal supply to the extent of 3 crores, which was supplied by RP traders as an operational creditor, but it has been discounted and KK Finance is the company. So now the question is whether RP traders can submit a claim for these 3 crores.
No, still they are the supplier. So anyway, whether they have entered to independently some contract with KK Finance or anybody, the city is not concerned with that. As long as city is concerned, they are the suppliers. So they are the
No, but
operational
they have got the amount. See, as far as RP traders is concerned, they have received the amount.
Of course,
So
they have
now
received the amount, but as long as
it is kind of assignment. Suppose it kind of the loan gets assigned because they have the finance company has discounted the loan, and then so the supplier, original supplier, gets his funds, and who is the creditor now? KK Finance is the creditor.
no, but what happens is that as long as I am the customer, right? Now he has got the discounting done, correct? From
Correct.
some finance company, invoicing you would have discounted, so it won't be considered in my.
See, I can add one more thing. See, normally what happens is when you discount a bill, whether it is with recourse or without recourse, two options are there. It is with recourse. Suppose with recourse means suppose KK Finance has discounted the bill and given the finance, and there is no amount coming in, and then KK Finance can go back to RP traders and ask for repayment of the amount. That is with recourse. And there is a without recourse facility where KK Finance discounted the bill, and then it is without recourse. Without recourse in the means he cannot go back to RP traders and demand money. His option is only to recover from the corporate debtor. Okay. So corporate debtor, he has no recourse to the original drawer of the bill. So he has to get it from the payee, and payee has defaulted. As a discounting person who has discounted the bill without recourse, then he has to fend for himself. Then he has to go to corporate debtor and get the amount. So when you say it is a recourse bill with recourse, what you say is correct in the sense that they can RP traders can say that provided he has repaid to KK Finance. Because he has discounted the bill and then money has not come and he has repaid to KK Finance, then he has to claim it from corporate debtor. But if it is a without recourse bill, KK Finance has discounted and RP traders will automatically say, boss, this is without recourse, so don't come to me. Then he has to go to corporate debtor. Then he has to file
Sorry,
a claim.
it was disconnected from my end.
Sorry?
I said, yes, I agree. And it was disconnected from my end while I was talking.
Yeah, it's okay. So basically, it all depends on how the transaction taken place, and then in case KK Finance has to like recover from the corporate debtor, he would file a claim, and then his claim in that case would be the claim for the term loan of 6 crores, and then for bill discounting of 3 crores. So he'll submit a claim for 9 crores, and then his voting share will also be to the extent of 9 crores. So that is what my opinion is that, and So there could be so many variations which come, and then there will be so many things where sometimes you know whether. So at the time of admission of claims, all these possibilities have to be explored, and then we have to see. And uh, as far as I know, there is one more session on claims and admission of claims and all that. So in this workshop, so maybe these questions will come up at that point of time. So now I just gave this example to highlight the constitution of CoC can be a bit tricky depending on how IRP admits the claim. Then a lot of questions take place, and then see you have a limited time of 23 days. Within 7 days of getting the claim, you are supposed to finalize the list of claims and file an application to adjudicating authority. So within that period, it may not be possible for the RP to admit all the claims, and he cannot also reject all the claims unless he has complete information. And RP has no adjudicating powers. He cannot, judicial powers are not there for him to reject a claim. He has to simply collate the claim. There are so many judgments which has come saying that RP has to simply collate and then mention. But of course, he has to get a proof for the claim. He has to see that whether the proof is valid, and he has to examine the claim and admit it or not admit it. But if he is not admitting it, he does not have the powers. So it becomes a very difficult thing for him to reject a claim. So so basically, the idea was to highlight a constitution of the CoC can be a bit tricky, and then we have to be careful in that area. So now what we will do, this we have discussed. So another question which has taken a lot of litigation is that why operational creditors are not in the CoC, because they feel that they have also equal stake in the business, and a lot of they also have a risk, and then their business also gets affected if a corporate debtor undergoes insolvency. But let us first see what BLRC says. BLRC is Bankruptcy Law Reforms Committee, formed in 2015, which is some kind of a prequel for IBC. BLRC has reasoned in its report that members of the creditors committee have to be creditors both with the capacity to assess viability as well as to be willing to modify terms of existing liabilities in negotiations. So, and it is the VLRC opinion, as well as generally it is agreed also, that operational creditors who are basically transaction based, they send a shipment or they send a load, and on that they are supposed to get creditors. So they cannot assess the viability of the corporate debtor as a whole, because they don't have that kind of information, and they also don't have that kind of capability. Typically, an operational creditor neither able to decide on matters regarding the insolvency of the entity, nor willing to take the risk of postponing payments for better future prospects for the entity. So this is also very important, saying that what is the what you can say is the holding capacity of the operational credit. So you have to maybe if you want to revive a firm and then be a member of the CoC and support what you call resolution and another resolution plan and change of management and all that, and then he has to wait for his money to come. And no operational creditors, as I said, it's all transaction based. They make a particular shipment, and then they would like to get that money and then move on. So they don't have this kind of capability. So assessing that, the committee concluded that the purposes of the purpose to be rapid and efficient, creditors committee should be restricted to only the financial creditors. So this is the decision given by the BLRC, and it has been accepted, and even the parliament it has been enacted into the Act.
So can I ask you a question now or sometime back?
Yeah, you can ask.
So what would be the situation, like we have talked about the classification of claim when there's a bill discounting with or without recourse.
Yeah.
Now suppose if it is with recourse and the person is claiming himself to be the operational creditor, though he is a financial creditor. Now in such situation, because the role of RP is IRP in the initial period is only collating, and subsequently RP also only collating the claims. So is there he will I believe only will put up before the CoC the way it is coming. What is the way to remedy such a situation?
What is the way to such a situation means this bill
Suppose
discounting
there's
you
a
are
wrong
asking.
classification by the claimant. The claimant
Okay.
itself is saying that I am an operational creditor. Okay.
Yeah.
Whereas RP is of the view that he's not just the operational creditor, he's actually a financial creditor.
Yeah.
Right. But now we don't have a adjudication power.
Yes.
So here I believe we'll call it and place it before the CoC.
No, see, CoC cannot decide on the admission of claim.
No, he
At least
will
RP
only
should,
admit put it, but
RP is
then
not expected to do. Sorry.
correct. Sorry. No, I just wanted to clarify. Sorry to interrupt. Now, in such situation, if there is a wrong classification by the claimant itself, what is the way out of it to have a proper classification?
See, normally what happens is other CoC members would immediately notice that this person is not a financial creditor and they might question. So they have an option to go to NCLT and ask for a decision on that. So in that case,
So
what
the
happens is,
RP would inform that CoC that if you are not agreeing, then you need to approach the NCLT, right?
see, RP has to take a call saying that what his decision is. Suppose, see, there are two views of, because I raised this matter of discounting because this is a kind of very debatable point. See, what I said was, since it is a bill discounting, it's a financial facility, he becomes a financial creditor. So another way of looking at is there's a provision saying that even if an operational creditor assigns his operational credit to another person, he does not become a financial creditor. He continues to be an operational creditor. So now one can argue saying that by discounting a bill, this finance company continues to be an operational creditor only. So I have no answer to that whether he'll be an operational creditor or a financial creditor, because maybe depending on what kind of document is there and what kind of discounting arrangement is there. So this has to be decided.
So the
Maybe see,
remedy would
normally
lie.
in practice, what happens is that RPs take legal opinions if they have such doubts, and depending on what the advocate says, that they take a call. Whether
Yeah, that is
so,
true. Now,
yeah,
suppose on that ground, the lawyer is advising RP that he is a financial creditor, though he is claiming to be operational creditor. Now,
correct,
RP doesn't have any adjudication power or to ask the party who has submitted the claim that you are not falling under this category. Now,
correct.
so in that situation, what I believe, and please correct me if I'm wrong, that's why I'm asking, that RP would simply place this before the CoC's next meeting that this claim has come, is claiming to be operational creditor. However, the advocates appointed by me says that actually he should be financial creditor. Now, if the CoC also agrees that uh, the claimant is actually a financial creditor, and if CoC wants it to be part of the committee, then the only way for CoC would be to go into NCLT. Am I right, sir?
Yeah, see now the advocate says that he has to be a financial creditor, and
Correct.
then going by the opinion of the lawyer advocate, the RP admits this particular person into CoC as a financial creditor. So if
No, he
other
will not admit because he doesn't adjudicate. He simply call it. So he will put, in my view, he will put it as an operational creditor with a note that though the claim has come as a OC, However,
Okay.
the advocate appointed is advising that
Mhm.
he shall be financial creditor. Then the remedy, if any, to be taken is the burden is on the CoC. That is the view I am
No,
stating.
actually, see now, if the operational creditor says that I have to be admitted in the CoC, and RP decides that he is only an operational creditor, he doesn't admit him.
Right.
Then it is for the operational creditor to go to NCLT and saying
Yeah.
that my claim has not been rightfully admitted, and then it has, I've been
Correct. So,
categorized as operational
yeah.
creditor,
So in
so
that
he can
situation,
go to NCLT. He
yeah,
is the
so
aggrieved party.
yeah, understood. But that was the position, I believe, not now, because now the role of RP is not to reject the claim.
No.
He simply collates the way it is
Yeah,
coming.
agreed.
And
See, one
because if
aspect
he
I would like
rejects,
to,
he is risking further litigation also from IBBI questioning and that's why your role is only to call it. If at all
agreed.
somebody
See,
is aggrieved, it is the CoC who is aggrieved.
your role is agreed to only to collect, but then he has to say which category. He has to know which is who is an operational creditor, and depending on the transaction, he has to say whether it is an operational matter or a financial matter. That RP has to decide. And one more thing I would like to emphasize when what you have been saying is that you are saying that put it up to CoC and let the CoC decide. So as far as I know, CoC has no role in admission or rejection of a claim. Others can, support or whichever way. But then my CoC has no role in this. So RP should not go to CoC and put it up. See, what RP has to do in the normal course of his duties is that he has to put up a list of creditors, and then what is their admitted amount, and what is their what is their voting share, and all these things have to be put up. So basically he has to take a call, but he cannot shoulder on the CoC, and he asks CoC to decide whether somebody is a operational creditor and what is his share and what is his vote
So,
share and all
sir,
that.
isn't
He
he
cannot
doing
decide.
the adjudication in that case? Because you are deciding that no, you are not a say operational creditor,
Adjudicate.
you are actually a financial creditor. So to that extent, he is actually doing the adjudication.
Agreed. See, it's a fine line distinction between, when what RP does is whether it's an adjudication or is collation or simply listing out the claims. So these are all subject to a lot of interpretations,
Yes.
and always doubts come. That is why
Yeah.
I'm saying constitution of CoC can be very tricky. And but what I would like to emphasize is that what you are saying now, let the RP put up to CoC whether what he has done is correct or not. That part is not the right thing to do. I don't think CoC will decide on the admission or rejection of claims. If we'll go forward and see what
Because
are
I
the
am not on
duties.
admission and rejection. I am only on the classification. That will
Classification
classify
also, see, it is
based on the submission by the claimant itself. Is saying I am a operational creditor. Okay, but RP, collating but putting a note to the CoC that the claim has come as an operational
no,
creditor.
agreed.
However,
You put a note to CoC. Is that part I am saying that that is not the what you call laid down procedure, in the sense that RP has to take, he collates or because see, RP has to collect evidence, supporting documents. He has to collect. He has to go through them, and he has to see whether the supporting documents support the claim, or if they don't support, then you should tell the claimant, saying that look, this is your claim, but the documents do not support. That he has to say. Where he may be see, there are RPs, there are so many RPs who do not accept a claim. It is not possible that every time every claim you comes you have to accept it. That is not possible also. So definitely there is an element of what do you call decision, whether it a claim is proper or not proper. That has to be there. So only thing is
thank
that
you.
Raghuram,
RP is not an adjudicating authority. That is what the law says.
excuse me, Raghuramji, can I come in? I am Munish Sharma.
Yes, sir.
Do I have permission to intervene?
Yes, sir. Please, please.
And who was the gentleman asking question? I missed his name.
Mr.
I'm
Prakash.
Pandya.
Prakash
Hello?
Pandya.
हाँ जी।
Mr. Prakash.
Prakash Pandya ji, I'll advise you, you go through a case that is Greater Noida Industrial Development Authority versus Prabjit Singh Soni. It's decided by Supreme Court somewhere on the last week of April, something like that. I'm not sure. Somewhere April 2024 case is there. That is Greater Noida Industrial Development Authority versus Prabjit Singh Soni. The Supreme Court has clearly laid down the forms in which claim is filed is not mandatory. It's a directory. It may so happen an OC may file claim in as an FC or FC may file claim as FC. It's a duty cast on RP or IRP to let the claimant know that he has filed claim in wrong category. Even if it does not amend it, you admit the claim in the correct category in which it happens. Now you are saying then FC is filing claim as OC, and if suppose there was a reversal, OC files claim as an FC, will you accept him as an FC or accept as OC?
I got your answer. Got the answer. Thank you, sir.
Okay. Okay. So if the claim you filed
I
is
read
wrong,
the judgment and I miss it. So thanks for reminding.
है ना? तो ठीक है पांडे जी,
Yeah.
क्लेम अगर
Thank you.
गलत फॉर्म में फाइल्ड है तो प्लीज मेक श्योर दैट यू करेक्ट इट, you
Yeah,
admit
yeah.
in the
Normally
right
we
category.
write, can you please correct it? Normally we do write.
Yes. Okay. Okay. Thank you for your time. Thank you. Thank you, Raghuram ji.
Thank you, sir. Thank you. So, so now what we were doing is we were discussing about this constitution and all that. Now we are at 3:55. Before going further into the actual constitution and other aspects of meeting and all that, we can take a small break, and then because it's almost 1.5 hours now, 2.5 two. So should we take a break and then assemble after 10-15 minutes?
Yes, sir.
Yes.
Yes, sir. Yes, sir.
Anjali
So
madam
if you
is
could
there?
tell the time, then it's better.
Yes,
When we are here.
yes, great.
Okay. So I think can we assemble at 4:10 or
Yes,
4
sir.
4:10?
Yes, sir. Yes, sir.
Okay. Okay, fine. Okay, we'll assemble at 4:10. Thank you very much. Ma'am, we can start. So I shall continue the discussion.
Yes, sir.
This I'm trying to share. I think share is continuing. Can you confirm whether you are able to see the slides? Anybody who is not able to see the slides?
It is visible, sir.
It's visible, visible.
Okay.
Go ahead.
Thank you. So we were discussing about the case, and then they said why operation creditors are not members of CoC. We also discussed what the BLRC said and what are the court judgments are also. There's a very significant decision of the Supreme Court in the Standard Chartered Bank versus Satish Kumar Gupta and others. There also it was clarified that um, the financial creditors have the primacy as in the committee of creditors. There it was said that the court ruled that the creditors can be classified into different categories, that is secured and unsecured, operational, financial, and all that, and they can be treated differently based on the nature of their claims. So this clarification came, and this was very significant because see earlier this judgment of the Supreme Court came in response to one NCLAT order in this case, SR Steel case, where NCLAT said that all the creditors, whether operational creditors or financial creditors, have to be treated equally, and then equal share has to be decided. And NCLAT decided on the what is the quantum of um, amount which has to be settled to operational creditors and financial creditors and all that. They kind of reworked the resolution plan and gave it. So that was another matter where it was very clearly said that adjudicating authority or the appellate authority cannot what do you call it, do any modifications of the resolution plan once it has been approved by the CoC, because the commercial wisdom of CoC is what do you call supreme. So now going next, I have another slide to show you. This we have discussed earlier also. The timelines relating to constitution of the CoC. I've already told you that this has to be done within the 30 days. And then what is the time limit for submission of claims and all that. Only one thing I would like to touch upon, which I have not done before, is that submission of claims is the time limit, general time limit is 14 days from the order once the public announcement takes place. But the claimants can submit the claim up to 90th day of the commencement of the CIRP. That is possible. It is not that within the first 14 days they have to submit, but whenever the claim is submitted, within 7 days the RP has to IRP or RP has to like take a stand on the claim whether he admits it or not admits it, and then he has to inform. And then this also we have discussed, application for appointment of RCAR has to take place within 2 days from the verification of claims. But generally what happens is it takes time for the adjudicating authority to decide on this application and approve the AR. But within that time, first CoC meeting has to be held. So it is generally not possible for the adjudicating authority to complete the appointment of the AR before the first meeting of CoC. So just to clear this gap, a recent amendment has come where once the home buyers or any class of creditors have approved a particular AR, then he can continue to attend the meetings and he'll function as an interim AR. So this is the recent amendment. So now going forward, how frequently the CoC has to meet? The first meeting of the CoC shall be held within 7 days of the constitution of the committee, which we have already just said. And then going forward, RP conducting the CIRP can convene subsequent meetings if the CoC as and when he considers necessary. So it is the prerogative of the RP to convene a meeting of the what you call CoC. See, there are some instances where people having 100% majority in CoC, they'll say, you conduct a meeting on so and so day, or you please convene a meeting and all that. But ultimately, it is the RP who has to convene it. But of course, the RP shall summon a meeting of the CoC if a request to that effect is made by the members of the committee representing 33% of the voting rights. So this provision is also there, saying that CoC member with or members with the 33% voting share, they want to have a meeting, then RP has to meet. Of course, he has to ask why the meeting is required and what are the things to be discussed, and because he has to share the agenda and all that, those things he has to collect and then convene a meeting. So, sir, he can inform the other members of the CoC why that meeting is being called and what is the item to be discussed. Then one more specific thing which is mentioned in the guidelines is that every meeting shall have a serial number. Of course, this is generally done. The first meeting, second meeting, third meeting, and then most of the RPs follow this process. But it is mentioned specifically in the guidelines. Then a meeting may be convened on any day, any time, and place as the RP deems fit. So it is again RP's decision who has to decide when he'll the meeting. Again, he cannot say that no, somebody said you have to do it on a particular day. I'm doing it. It is not that. That is the prerogative of the RP. And of course, national holidays are to be left out to the extent possible. And the convenience of the members and their geographical location must be kept in mind. These are all the normal things most of the RPs do. But a situation demands that he has to have a meeting urgently or within the period, within giving a notice and all that. So it is to be done. Now, recently, it has been laid down that at least CoC must meet at least once in a month. But it is also provided in the provisions that if CoC decides that he can extend this time gap to 3 months. So they can say that no, it is not meaningful to have any meeting every month. We can have a meeting every quarter, depending at what stage of the CIRP the company is. Suppose CIRP resolution plan has been submitted and we are waiting for the approval of the court, and then we have nothing else to do, so there's no point in meeting every month or something like that. So depending on the situation, the CoC can agree that they'll have a meeting once in a quarter. But at least once in a quarter, you should have a CoC meeting. That is the guideline. So this is as far as when the meetings have to be convened. Then another aspect we should note is what is the how the notice is to be sent for the meetings. A meeting of the CoC shall be called by giving not less than 5 days notice in writing, along with the notes on agenda to every participant. So this is common knowledge that the 5 days notice is required. So this is done. But that is why most of the RPs, they feel that this has become difficult. They generally put it in the first meeting itself that the meeting can be called with a shorter notice period, up to maybe 2 days or 3 days. The CoC may reduce the notice period from 5 days to such other period as it deems fit, but the notice cannot be less than 24 hours. So obviously it cannot be less than 24 hours, because if you want to have a meeting today itself and you tell in the morning and have a meeting in the evening, or tell at 10 o'clock and have a meeting at 2 o'clock. This is kind of becomes very difficult for the CoC members to be prepared, because we are also issuing guidelines to CoC members. They should be prepared and they should come well aware of what is happening and all that. So it has to be minimum 24 hours. And as I said earlier, that where an AR is there in the meeting, it has to be not less than 48 hours, because he has to give 2 days time has to be given, because at least one day he has to uh, take time to uh, get the views of his class of creditors. The notice is to be sent to the address provided by the member by hand delivery or by post, but in any event be served on every participant by electronic means. So it's very clear. Most of the times, I mean, nowadays what happens is mostly we send by electronic means, and most of the times I have not come across people sending by physical copy of the CoC meeting notice to others. But there is a provision that you may have to send it by hand delivery or by post. But it has to be necessarily sent by electronic means, which is by email or something like that. So again, it is specified in the guidelines saying that this may be as a text or as an attachment to email or as a notification providing electronic link or URL for accessing such notice. Why so much of specific direction is given in saying that they want to make sure that people do not cut corners, or people think that okay, I've sent it, this is good enough or something like that. So all the specific guidelines are given. Then the subject line in email sharing notice of the CoC meeting shall state the name of the corporate debtor, the place, the time, and the date on which the meeting is to be scheduled. So it has to appear in the email subject line itself. This is very much required, because most of the times we see the subject line and open the mail. And so because if you give a different narration or something like that, it is possible that people may miss the notice. So this is very specifically laid down, so that to the extent possible, all the confusions arising out of I have not received a notice, I don't know, I didn't know the meeting was there, and all that, all such things are cut down, because um, uh, time is the essence, as we know in IRP, CIRP, and then we cannot spend time in all such things. There are some more items. Notice is to be given to all the members of the CoC, including AR, the members of the suspended board of directors or partners in case of LLP, suspended board of directors, operational creditors, or their representatives, if the if the amount of their aggregate dues is not less than 10% of the debt. So I've come across some case law where this interpretation. In fact, there was a disciplinary action case was also which I read. Where saying that um, the aggregate dues of the operation creditors was more than 10%, but there's some interpretation problem was there. Um, the aggregate is interpreted as if the claim is more than 10%, then you treat it as that person has to be given an invitation. Otherwise, it was not done, because sometimes it has been done that way, but there has been a clarification. There was a judgment also, which I'll share going forward at the end. So it says that if the the aggregate amount of the operational creditors claims is more than 10%, then you need to invite one representative of the operational creditor. So you can, how it is to be done, I don't think it is, I have not come across any guideline where specifically it is mentioned, but generally, if you have some operational creditors, maybe 10 people or maybe 20, whatever people, because sometimes one person has a big claim, but if what you need to do is you need to send a mail to operational creditors. Look, since the aggregate amount is more than 10% of the total amount, so in case if you want to attend the meeting, you please identify a representative among yourselves. So I remember one case where for employees we conducted a meeting. Employees because there were huge amounts were there. Then we said one representative of the employees can be um, identified and he can attend the meetings. For that, a separate meeting of the employees was conducted. So the only way is to write to all the operation creditors and ask them to identify, or probably RP or IRP can identify a person among the operational creditors, suppose the highest claimant or something like that, and they say this person will represent, and of course you have to take his consent, and then others can maybe give their consent for this, or they have to, and they have any issues, they can share with this person. So this is the way basically you have to facilitate a one person operate a representative of the operational creditors to attend the meeting. Of course, it is given that operational creditors they have to only attend the meeting; they cannot vote. They can participate. Maybe they can express their views or whatever. But voting is not permitted. Then operate resolution professional, if required, may invite such other persons where presence of such invitee is required. This is generally done in CoC meetings. Such persons may be include statutory auditors of the company or a senior management personnel of the corporator or registered valuers, forensic auditors, or if anybody. And I have also seen sometimes along with the AR for the home buyers, some home buyers also would like to attend the meeting, say that, we would like to see what is happening and all that. So I've seen RPs permitting some home buyers also, apart from the AR of the home buyers, to attend the meeting. But of course, they cannot vote separately. Then there is another provision which says that foreign insolvency practitioner or administrator of any given case may be allowed to attend the CoC proceedings in India. This is possible where the big cases are there where multi-country exposures are there and all that in such cases. But this has to be with the approval of the adjudicating authority. Then record of each recipient to whom notice has been sent and copy of such record and notices of any failed transmission and subsequent resending shall be retained as proof of sending. So basically, the idea is that when you send a notice, you have to have a record of that notice because that will form the CIRP record. And at a later date, you have to prove that you have sent the notice. But one thing it is already said that notices be sent simultaneously to all the members where possible. The RP should take all reasonable steps to ensure that the list of creditors is complete. But ultimately, if notice is sent and then to the mail ID given to the RP and it does not reach the uh, CoC member, it is not the responsibility of the RP. He cannot be held accountable. Anyway, we'll come to that as we go forward. The notice shall provide the participants the details of date, day, time, and venue of the meeting and of the option available to them to participate through video conferencing or other audio-visual means. So in the notice itself, we have to say they can, if it is a physical meeting, then they have to say you either come physically or you have the option to attend through video conferencing. Then you have to mention what are the arrangements made for that. Notice shall also provide all the information, necessary information to enable participation through video conferencing or any other audiovisual means. The notice of the meeting shall provide that a participant may attend and vote in the meeting either in person or through a representative duly authorized. So this is a person, a particular CoC member wants a representative attend for a particular meeting, then what he can do is he has to tell the RP in advance, send the identity, maybe share his ID card or something like that, and then he has to take an approval and then attend the meeting. RP authorized representative can be sent, but it has to be done in advance. The notice of the meeting shall contain a list of matters to be discussed at the meeting, list of issues to be voted upon at the meeting, and the copies of all documents relevant for the matters to be discussed and the issues to be voted upon at the meeting. This is very much necessary because COC members have to take a informed view of what is the required from them, what is the matter to be decided, and all that. And as I said, even AR has to have all this information if he has to share with the class of creditors and then take their opinions. All details of the proposal, relevant material facts, and that enable the members of the COC to understand the meaning, scope, and implications of the proposal. So these are all very specifically laid down items where when the notice is to be sent, how the notice is to be sent, what are the items which are to be mentioned in the notice. All these things are very clearly laid down so that even if a RP is taking up his first case, if he goes through the guidelines, then he'll be in a position to take care of all the requirements. Then next item would be what is the venue of the COC meeting. Most of the times question comes up whether COC meeting can be held in the office of the corporate debtor. Yes, it can be held. Whether it can be held in the office of the financial creditor, it also is possible that some bank wants to host because everybody would like to reduce the cost. So some bank would like to host, then it is possible that meeting can be held there. Or RP can have a COC meeting in his own premises. In his office itself, he can have, provided he has facilities for video conferencing and recording and all that. So it is the RP who has to decide the venue of the meeting. And the decision of the RP shall be final and binding. So this is again some empowerment is given to RP, but then it is all very clearly laid down what he has to do in a respective matter. RP shall choose a place which is convenient for persons who are invited to attend, but she should also ensure that the accommodation is adequate for the number of persons likely to attend. Very obvious. Where a meeting is conducted through video conferencing, all recordings of the proceedings of the meeting shall be deemed to have been made at the venue given in the notice. Okay. The link for joining the meeting shall be communicated in advance. So all these things, whenever you send a notice, mostly the link is also sent because it's a video conferencing. This is about the venue of the meeting. Then where the meeting is taking place through video conferencing, the members of the COC may meet in person or through such other electronic means as provided in the regulation. RP shall make necessary arrangement to ensure uninterrupted clear video or audio or visual connection. The participants have to be able to hear and see the other participants. That these are some of the things which are clearly mentioned so that disputes do not come at a later date. But obviously, whenever video conferencing is done, there has to be clear video and an audio, and there has to be facility for everybody to participate. The resolution professional shall take due and reasonable care to safeguard the integrity of the meeting by ensuring sufficient security and identification procedures. This identification procedures, we know that everybody has to say when the beginning of the meeting who is the person and how he is participating, what is the role and all that. RP has to take steps to record proceedings and prepare the minutes of the meeting. She has to show the physical and electronic records as per CARP records. This I have already said. The RP has to ensure that no person other than participants has access to recordings of the proceedings. Okay, so at the time of meeting itself, like somebody has to say that who is he and how that will be discussing now. The RP shall act as a chairperson of all the meetings of CoC. He shall conduct all the meetings of the CoC. So just because somebody has a big share, he'll not become the chairman of the CoC. That is the point to be emphasized. It is always the RP who is the chairperson of the meeting. The number of persons accompanying the RP for the meetings may be limited to 3, and these persons should not ordinarily speak unless specifically directed by the RP to speak on a specific issue. Okay, so the number of persons. So what happens is there is one guideline which says that RP cannot have a big team. I mean, there are a lot of sometimes it happens. There are lot of people are there, especially if the meeting is held in the office itself. There could be now a lot of people, but they should not be speaking unless it is required. Then, how the security and integrity is mentioned, what we mentioned earlier, at the commencement of the meeting, the RP shall take a roll call when every participant attending through the video conferencing or other audio visual means shall state for the record his name, capacity, his her location, that he has received the agenda and all the relevant material for the meeting, and that no one other than him is attending or access to the proceedings of the meeting at the location of that person. This is very important because what is discussed in the COC meeting can be very crucial, and then very important things for the corporate debtor can be discussed. So at that point, only COC members who are attending, who are entitled to attend the meeting, should be knowing the things. They should be other person should not be allowed. This RP has to ensure. Some more with regard to conduct. After the roll call, RP shall inform the participants of the names of all persons who are present and confirm if the required quorum is complete. So this is another important area where RP has to ensure that quorum is complete or not. So he shall ensure that quorum is present throughout the meeting. Not only that at the beginning of the meeting quorum is there, but he has to make sure that all people continue to attend, and it's not that somebody can be allowed to go away. Because after he goes away, suppose quorum is not there and a particular matter is discussed or some decision is taken, there could be a dispute. Another aspect, the RP has to take a confidentiality undertaking from the members of the COC before sharing information and the documents, like such as the details of the resolution applicant, valuation, financials, and resolution plans. Such documents are shared in electronic form. So this is also very commonly practiced thing, that confidentiality undertaking is taken. Without that, so some questions come like uh, whether suppose a resolution plan or something like that coming, it is given to the AR of the home buyers. So whether AR can share those details with the home buyers. Suppose there are 1,000 home buyers and you have to share the resolution plans, it becomes kind of public knowledge. Who is doing what and all that, whether that is permissible, that was the question. So, so sometimes they said let AR not distribute, he has to discuss in the meeting and all that and all. But the home buyers, there are people who would like to know the details of a particular proposal or anything like that. So the question is how it is to be done. So when AR has to get the details of any details or proposal, or anything, he has to give a confidentiality undertaking. And then in turn, if a particular home buyer or anybody wants to share, wants you that, you want to see what is the plan, what is this and all that, he has to submit a confidentiality undertaking to the AR. So RP would say it is up to the responsibility, it is the AR who has to decide what he has to share and with whom he has to share. Then AR can do, if because there's no point in refusing to share the details, because he is the AR for the class of creditors, and then he cannot say that I'll not share, because he cannot take views if details are not shared. So what he has to do is he has to take a confidentiality undertaking from the concerned person with that, because see, you don't you maintain, you read it, you maintain, you take a decision and give your views, but don't share it with all the people, like, like copy to all kind of thing, don't do. That is what the I mean solution is. Then the resolution professional shall circulate the minutes of the meeting to all participants by electronic means within 48 hours of the said meeting. So this is very strictly has to be done. Sometimes I've seen disciplinary action also takes place because some notice meetings are not, the minutes are not shared within 48 hours and all that. So these are some of the guidelines which are very specific, and then it is necessary for the RP to know what is the requirement. Then some more details about the quorum of the SCOC meeting I'm giving. After the roll call, the RP shall inform the participants if the required quorum is complete. He shall ensure that the quorum is present throughout the meeting. That already mentioned there. Then a meeting of the committee shall be quorate if members of the committee representing at least 33% of the voting rights are present, either in person or by video conferencing or by other audio and visual means. So minimum voting share, people with voting share of 33% should participate. Then you can say that the meeting is quorate. So the 33% is generally ensured. Then it is also possible that the COC may modify the percentage of voting rights required for quorum in respect of any future meetings of the committee. Why it would be required? Because sometimes a situation may come where suppose one COC member is having say 70% vote share. He might just attend the meeting and say that everything is he'll discuss for himself, and then others may not get a chance also. Even if others do not participate, it doesn't matter. That should not be the situation. In such a cases, the COC may decide that apart from his share, maybe another 10% vote share is required for the quorum to be complete. So that so to facilitate such requirements, this provision has been made. So 33% is generally required, but the COC may feel that no, 33% is not in this particular case. We require at least 70% or 75%. Maybe they can decide. The COC has the option. Then what happens if there is no quorum? If there is no quorum for a meeting, unless the committee has previously decided otherwise, the meeting shall automatically stand adjourned at the same time and place the next day. So if there is no quorum, the meeting will take place the next day, at the same time, same venue. But this will happen only if the committee has decided otherwise. So sometimes CVC may decide that if there is no quorum, what we will do is we will not have a second meeting. We'll adjourn the meeting or whatever decision they want to take. They have the what you call facility to take that. But if there is no meeting, no quorum for the meeting, meeting is not to be held. That RP has to ensure that. So in the event a meeting of the committee is adjourned, the adjourned meeting shall correlate with the members of the committee attending the meeting. So next day again, it will not get postponed to the second day because there is no quorum or anything like that. Whoever is attending, they'll participate in the meeting. So this is the as far as the quorum and conduct of the meeting is concerned. And then there are some guidelines about the attendance records of the COC meeting. Attendance should be complete in all respects, and signing and should be ensured within the meeting itself. So sometimes people may not give importance to the attendance sheet, but it is laid down in the guidelines saying that it has to be kept, and it is also forming part of the CARP records. all the details of the meeting shall be mentioned in the attendance sheet. Of course, when you have attendance sheet, for what purpose and all that will be mentioned. And if they suppose the RP records and authenticates the attendance sheet, it shall be deemed that those attending the meeting through electronic mode have also signed the sheet. Obviously, those attending through electronic mode will not have a signature there and the paper, but RP can sign it. When the meetings are held through electronic mode, the attendance list may be generated through video conferencing software. This is there, but maybe it is done. Sometimes it is done, but I will not come across all the cases where it is invariably done. But in the meeting, people are there and it is recorded, and RP confirms that, and that is sufficient. An electronic copy of all records of CoC meetings, physical and electronic, should be kept as per the record retention schedule advised by RBI from to time to time. As I said, all these things form the CIRP records, and they have to be maintained for 3 years or 7 years, and sometimes 8 years. So this, depending on those guidelines, it has to be maintained. So this is the position as far as um, records are concerned. Then some more guidelines. Most of the times these guidelines are generally known. So, but I'm only mentioning that, sometimes we might miss one or two things, and then suppose some audit takes place or anything like that. At that point of time, we should not be thinking that such a small thing is not taken care. And one more reason why I think IBBA is mentioning all these things very so specifically is that, um, IPs, people might be taking up the job, and then people, though experienced in their own field, are professionals, but uh, the kind of expectations of IBBA have to be made known so that everybody will follow, and the same system is maintained by all the RPs in spite of their various backgrounds. That is the expectation. So now I would like to share when I'd like to share an illustrative list of items which will be for the first meeting. This, of course, um, I'll just read out. Before that, we go to that. Are there any queries or any questions, any discussion which you required with regard to conduct of the COC meeting? Any notice and how things are there? Anything people would like to raise? I think we can do that at this stage. I'll also try to have a look at the chat if I can. Sometimes it is not visible to me, but then I'll try to see if I can get it. Well, so if there are no questions, what I'll do is I'm just sharing an illustrative list of items because this could sometimes be useful. What I thought was most of the times whoever is issuing a notice might know this and what is depending on the requirement that they do to it. But then there is an illustrative list of items for the first meeting which are available. So if you have a copy of this, you can ensure that you don't miss any particular item in the agenda. So what are these items? Of course, IRP takes, this is the first meeting we are talking about, and the IRP takes the chair, he ascertains the quorum, and then he asks whether COC is interested in reducing the notice period. We discussed that from 5 days, you can reduce it to 1 day or 2 days, depending on the requirements of the COC. Then you have to take a note of the list of creditors prepared by the interim resolution professional. So this is one of the requirements which RB has to ensure that the list of creditors is placed before the CoC. Then he has to take note of the steps taken by the IRP for taking control and management of the affairs of the corporate debtor since the insolvency commencement date. This, of course, whatever steps have been taken from the date of commencement of CIRP, then whatever steps, whether he has met those people, these people are able to cooperate, whether there is cooperation, whether no cooperation, if there is no cooperation, what they are doing, whether people are working in the office, whether it's a going concern, whether it is not a going concern, whether it's been closed for a long time, whether office is there, details are available, accounts are there, and then to what extent audit has been completed. Well, last 2 years it is completed. Last year, when was the last audit, statutory audit done? So all these things are important, which has to be discussed by the IRP during the meeting. Then important thing is the ratify expenses incurred to be incurred by the applicant as CIRP costs such as. So now the first question the COC has to decide whether they want to. Um, Most of the times, our COC decides that applicant will bear the cost himself up to the stage of constitution of the COC, but it has to be ratified and reimbursement if required. If the applicant says that please reimburse, then it has to be considered when COC has to take a call whether they want to reimburse the expenditure up to the formation of the COC. Then other expenditure, ratify the cost fee of the professionals appointed by the IRP for valuation purposes and all that it has to be seen, and then they have to COC has to take a call. Then they have to, most important thing is whether in the first meeting the agenda item is that they have to decide whether they want to continue the IRP or they want another RP to be mentioned to be appointed. So what happens is most of the times the applicant who filed the CIRP case would have appointed his own IRP, and then most of the lenders, banks have their list of approved IPs. Whether you are within that list or not, depending on that, they would like to continue the same IRP or not. So all these things, but this is an important decision which has to be taken in the first meeting. So once suppose the IRP is continued, then there is no point. He will continue, and if it is not to be continued, then new RP has to come. Then it's a different route. Then he has to hand over to the RP who is coming in, and then COC has to file with the adjudicating authority for approval of the replacement of the RP. So these are some of the things which need to be taken care. And similar list is also shared for I don't know whether they have that list with me. For other meetings, also similar list is shared. I'll share the list along with my what do you call presentation and all that. There are some guidelines which I'd like to share. There's a handbook of COC meetings is also there. That also can be shared for those of you who do not have such handbook. It will be very useful. There are some best practices for the RPs. All these things are available, which can be shared. Then there are some guidelines which we have to note with regard to voting. The resolution professional shall take a vote of the members of the committee on items which are to be on any item listed for. So, as I said earlier, in the notice we have to mention which are the items which are for noting, which are items which are for voting. So COC generally is not required to vote on every aspect, but sometimes we have to mention, and wherever it is mentioned that voting has to take place, then voting has to be done. The RP would make so in case of video conferencing and electronic voting and all that has to be done. The authorized representative of particular class of creditors will vote in the COC on behalf of all the financial creditors represented by him. So this is one aspect which is done, which is a new guideline, which is a guideline which has to be kept in view when a particular vote is there. Sometimes what happens is even the 51% voting is sufficient, but then AR has to represent the entire thing. So how this process takes place is that AR of a particular class of FCs will vote in the CoC on behalf of all the FCs represented by him, as per the decision taken by a vote of more than 50% of the voting share of the FCs of such class who have cast their vote. So, which means that if there are voting share, some more than 50% of the people said yes to a particular proposal, it doesn't matter whether the other 50% says no. So, if 51% says yes and 49% says no also, then the AR has to vote yes if 51% of the people are saying yes. So, but RP will count while counting the vote share, the 100% of the home buyers or any class of creditors has voted in favor of the particular proposal. This is the guideline which is given in the regulations. But there is a provision to that. I'll come to that a bit later. Um, at the conclusion of the voting at the meeting, the resolution professional shall announce the decision taken on items along with the names of the members of the committee who voted for or against the decision or abstained from voting. So this announcement has to be made. But that see, it is not that it's a confidential vote and we will not disclose what we are saying, whether we support or we do oppose or not. It is not, a member cannot say that it has to be kept voting is public, and RP has to inform all the other members of CoC saying that who has voted for what and whether he has voted or abstained or anything like that. But how this is done normally is that, when a CoC meeting takes place in a video conference, they'll say that okay, we'll vote. Most of the times people say that we need time. They ask for maybe 2 days, 3 days, and at that time RPs generally allow that time. And then there is a voting window, whether it is some site is there where the what you call user ID and all that is shared. With that you have to go and vote, and AR has to vote. First, AR has to ask all his class of creditors, all the home buyers, for example, to first vote in a particular site, and then depending on their vote, whether it is more than 50% or less, depending on that, he has to decide whether he has to say yes or no to a particular proposal. So once he says, then again his vote is taken by the RP separately, um, and he has to mention that okay, I agree or I don't agree. Then first there is a pre-voting minutes are circulated. Once a discussion takes place and it is decided that voting will take place, and it is mentioned that voting window will open on so and so date, and then it is circulated to all the people, and then AR will also circulate and say that this is the window opened and all that. So during the pre-voting, minutes are all shared. What was the discussion which has taken place and what particular item voting has to happen. After that, the actual voting takes place. Depending on the voting, the AR votes and other CoC members vote, and then RP collects all these votes, and then he declares that who has voted in favor. So what happens is that RP circulates a second minutes, that is final minutes after the voting is completed. So you have a pre-voting minutes and then post-voting minutes, which are the final minutes, where it is mentioned whether that particular proposal is approved or not approved. So depending on that, we need to take further course of action. That is what the general process which is happening. Then some more guidelines here, where two or more resolution plans are put to vote simultaneously. So again, probably you might have come across this. Suppose, and earlier there was a practice saying that suppose the resolution plan, as per these parameters and all that, or evaluation criteria. Suppose the resolution plan, whichever gets the highest mark, that used to be put up. but there were always disputes and all that. And then it was decided that, all the resolutions plans will be put up for voting simultaneously. And then a CoC will decide, and they will vote on each and every proposal. It is not that only one proposal which is the highest they will vote or something like that. So the information is given to the members of the CoC. They will vote simultaneously, which and the one which receives the highest votes, then it gets approved. But generally, it would have been decided that a minimum quantum of voting is required for approval of a proposal, and that threshold has to be crossed. So this is what the thing is. And then, as I said, that circulate the minutes, and then after minutes, okay. One thing which is mentioned here is that voting, whenever it is taken, it has to be kept open for at least 24 hours from the circulation of minutes. So minutes are circulated, then you open the window, at least you keep it open for 24 hours. And then only then you can satisfy that sufficient time has been given for all the COC members, including the class of creditors and all that, they have been allowed to vote. The AR shall circulate the minutes of the meeting to creditors within a class, then open a window for voting 24 hours. Such window shall be kept open for at least 12 hours. RP has to make arrangements for such electronic. So all these time elements has to be kept in, because otherwise you approve something and ultimately this is disputed, the entire process becomes a waste. That is the basic idea. After the voting is closed, the RP shall make a written record of the summary of the decision taken on a relevant agenda item, along with the names of the members of the committee who voted for and against and abstained voting. Such a written record is to be circulated to all the FCs by way of post-voting minutes and within 24 hours of conclusion of the meeting. So earlier, minutes used to, after the meeting, 48 hours is the time given for circulation of minutes. After the voting is done, within 24 hours, you have to circulate the minutes. Then there are some items which we need to take care when minutes are made. The minutes of all meetings of a particular CIRP will be bound together at the end of the period of CIRP for safekeeping by this. So which means that you have to have a physical printed record also, and then you have to make a binding of that and then keep as a CIRP record. This is very much required, apart from the um, soft copies which you are holding. The record of retention schedule advised by, like earlier I mentioned, that the same 7 years or 5 years, whatever schedule for each item is maintained. Minutes shall not be tampered in any manner after being finalized, post gathering of comments from the members of the committee. So, obviously, you cannot tamper the minutes once it is finalized. That's why you put it in a PDF and send it. That is also mentioned somewhere that whatever minutes you are sharing should be in a PDF format. Then for the convenience, it is also mentioned what are the minutes, contents and all that. The RP shall maintain a uniform and consistent form of maintaining the minutes. He shall maintain its minutes in physical as well as um, he shall maintain its minutes in physical as well as electronic form at other his office or where the CARP is conducted. So he has to maintain. It is not that why it is specifically mentioned at his office is that you cannot say that all the records are kept with CD's office. No, no, it is not like that. You should maintain your own records. And then most of the, I think our CDSL also makes a provision that you can submit soft copies. You can take some space and deposit all the records. So such things should be made use of. So general contents again is all specifically mentioned saying that serial number, name of the corporate debtor, all these screenshots be there. I'm not repeating that. Record the names of COC present and resolution proposal. So all these things. So you have to mention the people of among suspended directors who was mentioned and all other invitees. All these names should be included. It is not that you mention only the COC members. And there are some more guidelines which you are finding. Sorry, one second. So these are all a repetition of some items which you have already talked about. And then there are some things which we should note, that the views of the dissenting financial creditors, we have to record that. Just because sometimes something is accepted, you ignore the views, that is not healthy. So views of the dissenting financial creditor has to be recorded. And those FCs who are abstaining for any particular, either for the meeting itself or for the particular voting purpose, that is, of course, we have also said that whoever is not voting, who is abstaining, who have voted against, all these means have to be very transparently mentioned. Um, So all these things, whatever happens in the COC meeting has to be mentioned. Ensure that this will ensure that justification for the decision is available at a later date along with the related records for analysis and verification. This is obvious because, if you um, suppose sometimes some dispute comes at a later date, if you don't record whatever happened, then we may not remember ourselves why we said something like this, or what, who said what, and for what purpose this has been discussed. These are all, the minutes shall contain a fair and correct summary. RP shall be proceedings of the meetings. A matter should be reasonably regarded as. So any items, suppose some dispute takes place, some fight takes place in the COC, you don't have to record all that. That's what it is said here, which is generally taken care. Matters which should reasonably be regarded as defamatory of any person, irrelevant or immaterial to the proceedings, need not be mentioned. Minutes shall be written in clear, concise, and plain language in third person or past tense. Resolution shall, however, be written in present tense. Minutes need not be exact transcript of the proceedings. Sometimes people ask you just record what I'm saying. That need not be done. You just mention what is the gist of it, that is sufficient. So then, what are all the items which COC has to necessarily decide? There is a big list of items. Of course, see, earlier there was a circulation of, there was a charter which says that what RP can do, what COC can do, so that it is all clearly laid down. So there is no confusion whether it is something is RP's duty or he has to take approval of the COC. Some things I have mentioned here, items requiring decision of the COC. Confirmation of RP, yes. Filing application for replacement of IRP, that COC has to do. Ratifying the expenses of IRP, COC has to do. Modifying percentage of voting rights, we have discussed this. And this, which I have not mentioned, is specifying the criteria for prospective RAs. Resolution applicants, who can be resolution applicant, how on, these are all very items which need good discussion, and a lot of what you call brainstorming is required. Like who can be a resolution applicant, and then they have to be laid down clearly so that at a later date when you are evaluating a resolution proposal, we are very clear why something should be approved or not approved. Then specifying criteria for prospective resolution applicants, reducing the notice period for holding. These are all normal things. And then we also have approval of interim finance. Interim finance requires approval of COC. RP cannot simply raise a finance and saying that okay, then because it forms the CIRP cost, and then he has to be repaid, and there's a question of charge, whether any the interim finance will have any charge, whether it will be unsecured. If it is charge, then who will share the charge on the assets? All these questions come up. So interim finance is a very important thing which has to be decided, discussed, and then finalized. Then RFRP, all these things, the request for evaluation, all these things, evaluation matrix, and then request for resolution plans. All these things are very much required. So this again, I've given a list of illustrative list for the other meetings, which of course uh, we know what are the things like it is similar to the one which we have discussed. The only thing is that expression of interest and request or resolution plan are different stages of CIRP. Whenever these things are coming up, you should include in the agenda and discuss. So these are some of the things. Okay, so basically these are all very obvious things, and most of the things are guidelines are very clear. So we thought, I mean, I just mentioned some of the important things, and most of you are aware of these things also. So any other item which specifically if you want to discuss or any doubts we can raise at this stage before I can discuss some cases also which related to COC. But there are a lot of case law, especially relating to approval of resolution plans and all that. Before we go to that, is there any item which, as far as process is concerned, any specific issue you might have come across during your practice or anything like that? If anything is there, it will be very nice to discuss. I see one question in the chat box. Is approval of minutes of the COC meeting necessary? Or is RP has discretion to draft the minutes and circulate the same? If any participant suggested changes in the minutes but RP doesn't find them necessary, shall he treat the minutes shared already as final? Well, first part is approval of the minutes of the COC meeting is necessary. Approval is generally any meeting, especially any meeting also. It's, whenever there is a meeting minutes in the next meeting, we ask whether the minutes of the meeting of the previous meeting, which has been circulated, whether they are accepted or not. So approval, see that is basically in the next meeting it is approved. But somebody says that some question has to be some changes has to have takes place, and whether RP finds does not find it necessary, whether he shall treat the minutes. My opinion is that yes, if RP ultimately RP is the chairman of the meeting, RP has final say on things which have to be discussed and what has to be not to be discussed. And if he feels that minutes need not reflect what has been, because I also said that there is a guideline which says that um, if whatever is felt not necessary it cannot be can be ignored. You need not mention that whatever exactly point to point or transcript of whatever discussion has taken place that has to be recorded. That is not there. What we can do is if you find that particular thing, suppose what happens is mostly what I find is COC meetings, especially in the initial stages. Suppose there is a home buyers meeting, home buyers are participating. What they'll do is they'll try to blame the builder, or employees are there, or some employee representative is there. He'll try to blame the directors. Such things do table, and sometimes directors also respond, and such things need not be recorded. And if you feel that they do not contribute to the decision making process, I feel we can say that they need not be recorded, and minutes as they say, as they stand, which has been circulated, that are final, that can be done. I think that is possible. That is my opinion. Can Google Form be used for voting? Uh, No, actually, generally the practice is to have more robust systems than Google Form. There are different sites which say that there is I have gone through sites like Right to Vote, this e-vote and all that. There are some things they see they give much better record than the Google Form. And Google Form can be restrictive. Suppose you want to discuss a particular proposal, a resolution has to be quoted, and then on that resolution, how many people have said yes, no, and all that. I've seen better reports which are generated in other sites. So I prefer to use such sites rather than a Google Form. I mean, Google Form is kind of restrictive, I feel. I don't know whether you can devise a Google form which gives most of the details. That is another matter. But there are better sites which can be used. That's what my feeling is. Any other opinion, I would welcome.
Good evening, sir.
Yes, sir.
Sir, one suggestion we require any contempt proceeding during the
Uh-huh.
CoC meeting where the RP will approach any contempt proceeding means any type of event or any that is contempt discussion or any proceeding,
Okay.
anything
Okay.
the RP wants to proceed anything which the CoC is making a contempt that is not in the law of IBC, where the RP will approach.
Um, what you are saying is when RP wants to go file a contempt application, but whether COC has to approve it. That is what you are asking.
When RP is making any suggestion or RP has got any order or RP has suggested by somewhere which is legally in the IBC, but the CoC is denying. That means the
Okay.
proceeding CoC is contempting the proceeding of the RP, or any obstacles creating, or any misbehave creating, or any manipulation is creating at that time where the RP will approach.
See, sir, I mean, um, from the details what you are giving, contempt application will be when you file a contempt, some court order is already there and that has not been complied with. That is why you are filing a complaint, contempt of. It is a contempt of court which you are talking about, right?
Yes. My overall view whether RP proceeding is a court proceeding or it is a normal proceeding. Whatever
See,
the RP, when
if a
RP or
particular,
IRP is conducting a meeting, is it a
okay,
court proceeding or a normal proceeding?
it is not a court proceeding. COC meeting you are asking.
Yes, sir.
I don't think
COC
COC
meeting is
meeting
a
is a
court
court
proceeding.
proceeding, but it is definitely a official thing. It's a kind of definitely it is a record, which is because RP is a court appointed official, but
Yes,
you cannot say that it is a court proceeding. It is not because we are not a judicial officer that you will convene a court and have a meeting, have recorded and all that. So I don't think as far as my limited knowledge goes, it is not a court proceeding. Definitely not. But it is important. You have to record that, and at any particular point of time, you can produce in the court saying that this is what, because while deciding on any particular course of action, whether approval or resolution plan, NCLT definitely looks into the COC records. And you must have seen many orders of the court where NCLT specifically quotes in the so and so meeting, number so and so meeting of this, the COC decided this and all that. So definitely it has a lot of value. But I'm not sure any advocate should tell me whether court proceeding is. I think my feeling is court proceeding is something definitely different from COC meeting. So, so that is what it is.
thank you. Thank you.
So my feeling is that it cannot be equated with that. And this contempt application you are talking about, it is to be like, if see, I would say that what is the importance of the order NCLT initially has given. The order, suppose you say that you take over some assets or you sell some assets and the order is there, and then suspended director is not implementing that, or depending on the importance of that particular order, whether you have to decide whether you go for a contempt application or not. If it is very important for the proceedings of the CIRP or for the corporate debtor, or COC feels that it is a very material thing, then CoC will definitely support going for a contempt application. And I've seen most of the cases contempt comes where where you file an application under section 19 and court gives an order saying that you have to do the cooperation. And then in spite of that order of the court, then cooperation is not given. In that case, RP says that let us file a contempt application. It helps. So at that time, RP can definitely go ahead and file the application.
Yes, yes, sir. Thank you, sir. Thank you. Thank you again, sir.
Sir, I'll join in 5 10 minutes. Meeting is going on. The meeting is going on. I'll join, sir. Yeah. Sorry. So that is what it is. Excuse me, please. Hello. Okay. Mm. Any other questions, sir? So now there are certain case laws which I'd like to show because which are related to thing. Some I'm not going into the details of the cases. Just like this some questions which have been come up like this. So this is one case where High Court directs IBBA to frame a code of conduct. I mentioned this. There is a High Court order. This is that particular order in Kuvar Sachdev versus IDBI. Then there is a. Then this also we were mentioning while passing. A related party having a bar of not being allowed to be a member of CoC cannot get over the said bar by a merely assignment of debt. So assignment of debt means if an operational creditor is assigning, then assignment of debt will not give him a bigger power to the assigned debtor. Similar one. So again, this is an important thing is that there is a provision saying that where the matter is under 12A, where the matter is in 12A, the 50% rule, where if 50% agrees, you vote as taken as 100%, that does not apply in case of 12A. That is laid down very clearly, but then this is a law which is supporting that, which is a case law. And this is one which says that there is no concept of dissenting home bias within the creditors in a class. Because, as I said, once 50% people say yes, the proposal is taken as approved by all the 100%. So the people who are not agreeing to this thing, they cannot become dissenting home buyers. There is no such provision in the IBC. So whether a CoC can negotiate after the finalization of the resolution plan and all that, it says that it is possible. Then when CoC approved a resolution plan and its commercial wisdom, it is presumed that the approval was given to a viable and feasible plan. So CoC, once it is approved, it is taken as a viable plan. And one more provision which we have to understand is that suppose CoC rejects a resolution plan, then court cannot say that that plan can be considered. So ultimately, it is a very clear thing saying that it is ultimately approved by CoC and which adjudicating authority can consider. Suppose something is rejected by CoC, then adjudicating authority has no powers to open that particular resolution plan. So these are some of the things. With this, I'd like to close. If it is all okay, then I'll close the thing. Anjali madam. If any other observations if people would like to make, then they are open.
Thank you, sir. It was a wonderful session.
Thank you, sir. Thank you very much. Yeah, I hope people, of course, see, these are all very matters which are very known, but sometimes, as I said, no, it is easy. It is better to have a revision. It will be very helpful.
Correct.
Thank you, sir. With that, I'm closing, and thank you very much for all your
Thank you very much, sir,
patient.
for such a excellent session.
Yes, sir.
Please
Yes,
share
ma'am.
the PPTs.